Hi, good evening, everyone, and welcome to another edition of our Justice and Pieces series. And today we have a very special it's the first time we're doing it. So I'm really excited to listen to an entire criminal defense firm. Roots of Law has graciously agreed to join us here today and the entire firm. So, first, I'm going to turn it over to Roots Gadia, and she's going to introduce everybody here. So, thank you so much, Roots, for joining us.
Thanks very much for having me, JP. Good evening, everyone. And I'd like to thank all of you for inviting us into your conference series that JP does. It's a great way to learn about the profession and learn how the profession impacts each and every single one of us at every point in the criminal justice system. I can tell you that by way of background, I've been practicing criminal defense work now for getting on to 25 years. It's the only area in which I practice. So too does my firm. We do a little bit of regulatory work, quasi-regulatory, but the predominant area that we practice in is criminal defense. And we do everything from the simplest of charges, domestic assaults, which we'll be talking about here today, right through into firearms, robberies, human trafficking, and murder. I have an amazing team of women in my life who are part of my office, and you will see them on the screen as I introduce them. I can tell you that this team works together like a cohesive unit, and one that I would not be in a position to do the job I do without their help. They are incredible at every single aspect of the work they produce, and I'm very proud of them. We are going to be presenting to you a case study in a domestic assault where the Crown proceeds summarily, and your role would be to take or engage the client through the various steps from arrest, rights to counsel, through the set date process, disclosure review, Crown pretrial, judicial pretrial, applications, pretrial applications, and then finally the trial itself. So to begin, I'd like to introduce my most senior lawyer, Paula Seymour. Ms. Seymour has been with my firm for just a couple of years now and has been a criminal defense lawyer working on her own prior to joining my office. I'm so grateful she joined my office, but Paula has been working for almost 12 years now, called to the bar, and she is truly one of the rising stars of the defense bar. Paula is going to be speaking to you about the initial arrest and rights to counsel and bail. Take it away, Paula.
Thank you, Roots, for that lovely introduction, and good evening, everyone. I'm really honored to be able to share my experiences with you and also particularly discuss bail hearings and rights to counsel. Before we decided to, when we were invited to do this, we all decided on which sections we were going to address with you. For me, I wanted to discuss bail hearings because for me, that's the juiciest part of the entire criminal process. It's the part that you tend to see in movies and on TV that they exaggerate and glamorize and whatnot, but I find it personally more entertaining in real life than even what they have on TV. So what I will first off, I have it organized in various sections. So I'll first discuss what a bail hearing is, why we have bail hearings, what happens before a bail hearing, and what happens in terms of before a bail hearing, in terms of how you prepare in advance of it, including giving the client the rights to counsel. Also what happens during the bail hearing and afterwards, and I'll give some final disclaimers. So first off, what is a bail hearing? So when someone has been arrested for a criminal offense and the bail, then you have a bail hearing, and that determines whether that person will be released from custody or they remain in jail. That's as simple as it gets, and that's essentially what the purpose of a bail hearing is. Now, why do we have a bail hearing? Well, other than the usual adage that you're innocent until proven guilty, if they were in jail, then you have a very limited period of time to talk with your client if they're in custody, because you have to schedule very limited periods of time to meet with them. It's difficult to go through disclosure. There's very little privacy when discussing confidential matters in jail. So it's obviously very helpful to have a bail hearing and have your client released in order to prepare them for their trial. So when a client is out, of course, they're in a better physical and I think psychological condition and position to be to prepare for the trial and work with you in that preparation. Sometimes I go with clients to the scene of an incident in order to better appreciate the lay of the land and go through the circumstances, appreciate the time of day, the weather, all that sort of thing. There's also more flexibility with scheduling appointments with clients if they're out. And also it helps clients to help me get witnesses for their defense. Now, what happens before a bail hearing is, to me, one of the more crucial points of what happens during the process of the entire matter, right up to the trial. And this is because officers are still very likely conducting their investigation and gathering evidence and meeting with witnesses or whatever they're doing in their investigations before in order to find evidence to find potentially your client guilty. So what happens before the bail hearing can affect your trial ultimately. So for example, in terms of evidence, the officers in the Crown may provide the video statement of the client, if they give a statement before the bail hearing, if they made any utterances by video or audio, if there's a video of your client in the cruiser upon being arrested, or at the Sally Port of the police station. There could be a video of your client at the booking station. These videos help to show what your client said, whether he or she has any injuries on them, what searches were conducted on the client, and whether the police gave any, if the police gave your client their rights to counsel, and which officers also interacted with your client. So in consideration of that, and also I should add also how your client was treated by the officers, what items, if anything, were seized by your client. So it's imperative even before the bail hearing that you give very clear instructions to your client about what to do, what not to do in order to increase the chances of him getting out of jail and even potentially winning the trial. So this leads me to another, as I said, and crucial point of the whole process, and that's the rights to counsel. Okay, so let's suppose that you have a friend or a client that's been arrested or is going to be arrested, and they call you for advice. They need your help. Now, or let's say if your client is even in custody already, they call you, they don't know a lawyer, they know you, they want your help. And let's say the officer is willing to let you speak with that client. Now, I appreciate for rights to counsel as a paralegal, you may not have that opportunity, but if you do, you're going to be well equipped now to know exactly how to deal with that. The first thing you got to tell your client, shut up. Do not say anything. Say nothing at all. Okay. That's if you don't do anything else, say nothing. Now, what does shut up mean? You'll find it very interesting and perhaps a little bit comical that you will actually have to explain to your client what not saying anything means. And this is because people always think, well, look, if I tell the officer the truth, it's like if it's in a Law and Order in a movie or something, if I tell them the truth, they'll be fine. They will you know, they'll let me go, they'll understand, and I won't get in any more trouble, and I won't have to be stuck in here, and I can go to work the next morning. No, it does not work this way. Explain to your client, there is absolutely nothing you can say, nothing you can do that will change their mind about arresting you. So you must say, there's nothing you can say. So you say nothing at all. And police are literally allowed to lie and trick you to get you to talk. They're legally allowed to do it. So if they want to, for example, if they want to say, well, your girlfriend told me that you punched her hard in the face. Let's say that didn't happen, but the officer tells the client, well, you punched me hard, that she punched you, she said you punched her hard in the face. Don't say yes, don't say no. I don't want you to lie. I don't want you to tell the truth. I want you to say nothing. In other words, if you just keep quiet. Now, if you feel compelled, because the thing is, when people are speaking with officers, they always feel compelled, like they have to say something or they must respond. There is no law that says that you must speak to the police, or that it's illegal, or you'll get charged with an offense if you speak with the police. So when if let's say an officer is trying to get you to respond to that, then just say, look, my lawyer said not to say anything. My lawyer said not to say anything. I do role play with my clients. I'll tell them, look, let's do this. What if the officer asks you how many eyes are in your head? My lawyer said not to say anything. Do you have hair? My lawyer said not to say anything. Do you live in a house? My lawyer said not to say anything. Do you know this girl named Jane? My lawyer said not to say anything. She said you punched her. My lawyer said not to say anything. She said you hit her with a club. My lawyer said not to say anything. You live on Jane Street or Richard Street, don't you? My lawyer said not to say anything. Sing that song. My lawyer said not to say anything. This is very critical. If you don't say anything, then you're going to be helping your lawyer, your paralegal down the road with your trial, because now they have nothing to hook you on. And police, you don't know what kind of lie or what kind of story the police are going to fashion around whatever comes out of your mouth. So if you say nothing, they have nothing to hook on you. And it makes our work easier for you guys down the road. And my colleagues will explain that a little bit further. So as I said, sometimes I go through a role play with them because people don't seem to understand what not saying anything means. Don't think that just because you're saying something innocent and you can't imagine it affecting the case against you, that it should be okay. You don't know what lie the police are fashioning around you or what story they're fashioning around you. You don't know everything. So that's why it's best you say nothing at all. You never assume, okay? So that now, if you cannot, worst case scenario, you can't give your client that opportunity to explain the rights to counsel, at least, but let's say the officer allows you to speak with your client, at least let them know, look, I'm not going to be able to speak with you or give you advice, but let me get a lawyer for you. I am working on it, and I'll get them to call you as soon as possible and they'll speak to you. But in the meantime, please say nothing at all. All right. Explain that as best as you can. Okay. Because they might try to get a statement from your client, but you don't want them to be able to get anything at all, even the slightest utterance such that they might fashion a story around that and hook you into, create some allegation against you. Now, once you've at least had an opportunity to explain the rights to counsel and the right to silence to your client, you want to get the names and numbers of potential sureties. What are sureties? Sureties are, in layperson's terms, kind of like jailers. They are people that your client knows, that they know well. It's not somebody that they just met just the other day. They're usually family members, long life friends, people who would know your client well enough that it can give confidence to the court to release that person. So the surety is someone who will supervise your client while they are waiting for their date in trial. This, as you see right here, that's being shared is the surety information sheet. And this is what we, this is some of what we give to a client so that they can appreciate what their role is and what their responsibilities are. So a surety, the three main things that that their role is, or that their responsibilities are one, to make sure that the client appears in court when they're required to. Secondly, that they follow the rules and conditions, if any, that the court has imposed upon them, to make sure that they keep the peace and be of good behavior, that they don't get into any further trouble by following those conditions. And three, that if the client does not comply with those conditions, that you call the police immediately. What are some of the conditions? As I said, it might be keep the peace and be of good behavior. In a domestic assault situation, it would be that that they have no contact with that person, that they must stay away from that where that person lives, works, or is known to be or ought to be. And they're not to have any even indirect contact with that person. That means they can't pass a message on through a friend to them, or send them an email, or leave them a message, or send them a text message. They cannot have any contact with them pending the outcome of this matter, because those things can lead to an arrest of breaching their bail conditions, and that will find them further back in jail. So once we get those sureties, we explain what their role is. We also work out a plan of supervision for them. This is, in working out the plan of supervision, the surety intake sheet that you see here before you, that's what we fill out. It's what also we provide to the court, because the police, for bail hearing purposes, may want to do a police records check or a criminal record check on the surety to make sure that they can be a surety for this person. As you see, it goes through what their status is in Canada, whether they have a criminal, any outstanding criminal charges, if they've ever been a surety before, and also who else resides with them. Because if they are going to be a surety and be required to supervise your client, they are going to be they may be residing not only with that surety, but also with the people that live at that residence. And the financial information also is for the purpose of showing how much the surety is willing to put up to secure your client's release. So what do I mean by that? In the States, you might see, you might hear that, well, people give a cash bail. We don't do that here in Canada. We offer, instead, you don't have to give money, you just have to show that you have it. So if you have some monies in your account, or if you have any assets, then you show that you have it, what the quantum is, and on the basis of that, your client will be released. This is also a way for the court to give confidence that you are serious about your role as a surety. So if you do not make sure that your client complies with those rules and conditions, then you risk losing the amount of money that you put up to secure your client's release, or the surety does. So that's how they make sure that the surety is very serious about their role as a jailer of sorts for the client. And some of these questions, as you see, these are questions that are usually asked of, not usually, they are always asked of the client in a bail hearing. And again, it also demonstrates that this person is definitely in a position to be able to supervise the client. So all of this I've already gone through, but I will say this in addition. Once you've spoken with those sureties and you've explained to them what their role is and prepared them, and this is not something you necessarily do in chronological order, but at least once you get their names and contact information from your client, It's also important that I think, and this is what I do, I speak with the police. If they're already in custody, I will ask the officer as much information as possible about the circumstances. I want to know what the charges are. I want to know when my client was arrested and where, the time. Sometimes these things are important to know. And also because you don't have all the evidence, you want to just gather up as much as possible because you never know if it could be helpful for you down the road in the trial process. You want to know, of course, which court the client is going to be brought before bail. If the client was arrested in the afternoon, they may be brought the next morning because whenever a client is arrested, they have to be brought to court within 24 hours. So if they're arrested early in the morning, it may be that they're able to bring them in the same day, usually by early afternoon at the latest. But if they're arrested in the afternoon or the evening, they're brought in first thing the next morning. Now, because of COVID, we don't do that anymore, at least for now. Most of the bail hearings that we do are done by audio or they're done virtually, which kind of helps us counsels with the legwork. We don't have to drive as far or rush off early in the morning. It's helpful to do it this way by video, but and you might find it helpful as well if let's say you're involved in a consent release. But in any event, until things change with COVID, this is how it's being done now. It usually, usually for the type of offenses that you're dealing with, they're usually dealt with under section 553, which are absolute jurisdiction offenses like theft under 5,000 or mischief under 5,000. And so under circumstances like that, while you would not have a bail hearing, you would have the client usually released, off on the street or wherever it is that the officer had arrested that person, and they're given what's called a Form 9, and it's another word, in other words, what we call a promise to appear, and that's a form that lets the client know when they are required to attend court and where they are required to attend court as well, and it's important that. When your client receives that form, that they appreciate the importance of this, because sometimes clients think, oh, it's just some piece of paperwork, maybe telling them that's a fine or something, or they don't tend to take it as seriously because if it's a more of an informal type of arrest. But please do impress upon your client that they must attend pursuant to that Form 9. Through the date and location, etc. Because if they do not, they will be arrested for failing to attend court. And that, of course, is an additional charge. It might cause them to, of course, they're going to end up in custody. They're going to be brought forward. It can cause a whole bunch of delay. It's a domino effect of problems. So please make sure that they make a note of the date, time, and location that they're required to attend in court. Sometimes it's about maybe 4-6 weeks after their arrest. And this is why some people tend to forget their court dates or their first appearances because of how long the time passes since their arrest. So do make sure that they keep a note of that. Now, what happens during a bail hearing? When a person is charged with a criminal offense, the case always appears at its worst when you have no disclosure. Disclosure is another word for evidence, and they're just mere allegations at play because you may see on TV, I'm sure, that someone's been arrested for an assault or guns and et cetera, whatever offense it is. Usually people see that and they think, well, if the officer arrested them, they must be guilty of something. No, they're just required to follow based on whatever allegations they're given. There's no exception to that, even in a domestic situation. People think that police are required to do a very thorough investigation before they make the determination to arrest them. They do not. All that's required in a domestic situation is for a person to say, this person made physical contact with my body without my consent. That's enough for an assault. Somebody hit me, that person hit me. That's an assault. That's it. That's all the police need to know. And they arrest you. They're not concerned about, not to say that they're not concerned, they'll gather as much evidence as they can, but they're not the judge and jury. And this is what I find a lot of people seem to misunderstand, even juries, not juries or other sureties, when I'm explaining to them the circumstances under which their friend or family member have been arrested. They don't understand why is it that the police are proceeding with this because this person lies and that doesn't make sense. The police are just required to do their investigation, gather as much evidence as they can, arrest the person, and they let the courts figure out whether your client is guilty or not. So that's my long way to say, this is all the purpose of a bail hearing. In terms of what the purpose of a bail hearing is, it's not to determine whether he's innocent or guilty. It's only to determine whether the court can feel confident enough to release that person into the community pending the outcome of the trial. All the evidence and everything, all of that's going to be figured out in court. For now, can this person be released without having any concerns about them committing any further offenses? Can the surety supervise this person properly to make sure they don't commit any further offenses? So when I have a client arrested and I've spoken with the police, I've also, on the day of court, I connect with the Crown to get the synopsis. The synopsis, as I said, is a summary of the allegations against the client. And I like to look through it to see whatever holes there are in the allegations against my client. Now, the thing is, of course, we don't have all the evidence. And because of having dealt with these types of offenses, I know what to pick at in order to weaken those allegations and just basically give the court more confidence about releasing him. Now, while this is not a circumstance you have to deal with, I'm explaining all of this to you because when you're dealing with the evidence down the road and the trial, you will know from the early stage what problems there were in the first place and what evidence there ought to have been in order to find your client guilty beyond a reasonable doubt, or what lack of evidence they have in order to meet that threshold. So I won't go through the details of what a bail hearing is, but I'll just say this, that it's a structured process. It's not about whether your client's a nice guy or not. It's not a character situation. The judge or the justice of the peace just looks at 3 grounds under which whether to release that person. It may be under the primary grounds, which means whether this person will show up in court when required. If the person has a criminal record of not showing up for court, that might be a concern for the court. But if they have no record, then that's not an issue. The second grounds are secondary grounds. Whether there's a strong likelihood that this person will reoffend. Again, if they have no criminal record, nothing to worry about. If they do, maybe it's a dated record and they don't really have any concerns. But even if they do have a record, the surety is there to make sure that they won't get into any further trouble. So that ought not to be an issue. The final is the tertiary grounds. And that's on the basis of 4 factors, which ultimately determines whether it be an offense to the administration of justice if the person were to be released. It's not, that's not a ground that's often used. It's not something you need to worry about so much, but I just wanted to give you just the skeletal aspect of how it's determined a person is released from bail. But after a bail hearing, if that person is released, as I said earlier, your client, if charged under Section 553, they'd be released and provided a Form 9. If they are released after a show cause or after a consent release, after a bail hearing, they'd be given a Form 10. And a Form 10 is an undertaking for which there may be a limited set of rules or conditions that they have to follow. Now, what is a consent release? And I should make mention of that. A consent release, when a client is brought before court, there's two ways that they can be released. It's either through consent or through the usual bail hearing, as I mentioned. A consent release, just merely all it means is that the Crown is agreeing to release your client either by themselves on their own, or what we like to say on their own recognizance, or under the supervision of a surety. They're fine with it. They're not going to fight it. We don't have to do arguments or anything like that as we would in a bail hearing. Sometimes the surety might be asked some questions, but otherwise the Crown's agreeable to releasing them, and they're not going to fight it. But going back to after a bail hearing, there's a third form to consider. And again, you guys might have been, this might have been addressed when you guys discussed bail hearings, I think before the break. I understand that you guys did a session on bail hearings before. And that is a form 11.1, and that's a release with conditions imposed in order, again, to prevent the client from potentially committing further offenses. Again, examples are keep the peace and be of good behavior, stay a certain distance from perhaps the location where the incident occurred, not to go back to that residence if it's a domestic situation. Your client would not be allowed to go back to that residence, particularly if the complainant already lives there. So those conditions will be listed out in that form, and they're required to follow that. If they don't, and they're caught not complying, they will be arrested again and then incur further criminal charges potentially, especially a fail to comply. So the final thing I want to mention to you is that, just as a few disclaimers as I close up here, when you're speaking with your client and when you're speaking with sureties, if you get to speak with the sureties, it's important to let them know to always be respectful, no matter how the situation goes be it with the police, no matter if they're being rude with you, or if the Crown is being disrespectful in court or the judge is being snippy. Always be respectful, because you don't know how the decision is going to go. You don't know how your conduct is going to cause a judge or justice of the peace to decide. Not to say that that is not supposed to affect them, but nonetheless, you always want to be respectful. Even if the decision doesn't go in the client's favor, I always tell the client still remain calm and respectful, because the decision can always be appealed in any event. And also, I'll add this as a final tidbit for all of you, that if you ever find yourself in a situation where you have a client that's arrested, you're not sure how to deal with things, you've never been in this situation before, I've always found in my 12 plus years of practice that the criminal defense bar is very friendly. You are always welcome to give any one of us here a call. We're not, we're all used to getting calls of all hours of the night, on weekends, sometimes, because this is how it goes when people are arrested. It's not necessarily a 9 to 5 situation when police are arresting you. Sometimes it's 2 a.m. On a Saturday night. So if you're ever in a situation where you don't understand how to deal with that circumstance, you're not sure what advice to give, or your client needs a lawyer, you're always welcome to give us a call. We're always more than happy to help you guys. And we'll be more than willing to help you, guide you through your own career as a paralegal. We'd be very excited to do so. And so to that, I give the floor and pass it on to my colleague.
Thanks very much, Paula. I appreciate those comments regarding our willingness to help out. We are available for anyone who needs to toss an idea about, or even get a little bit of advice on how to handle a file. I'm going to introduce next the process under which we then take our matter from bail and into the process of set date court. If all of you know, the set date court process has become a Zoom link process, and I'm hopeful, let's be hopeful and cross our fingers that we never have to go back into court and we can continue on Zoom. But the set date process, as you know, is designed to ensure that we get disclosure, disclosure being the Crown's case against your client. And as a result of COVID and the vast amount of electronic disclosure that our office now gets quite regularly on the Disclosure Hub, we had no alternative, and gratefully so, but to hire Roxana Sowell, who is now the Roots of Law disclosure clerk and is in a position to tell all of you why her job is so important to our firm and how grateful we are that she is helping us with organizing and setting up our disclosure files to make our lives just that much easier. Roxana, to you, please.
Thank you so much, Roots, for that kind and beautiful introduction. So as many of you know, I'm Roxana, and I've joined the Roots of Law firm in October 2020. And I'm so honored to have this opportunity where I could work alongside and learn from very intelligent defense lawyers. So I'm going to be speaking about my role here as the disclosure clerk and what that entails, which is reviewing all of the disclosure. So first, you might ask, what is disclosure? Disclosure is all of the evidence that the Crown and police has collected and will use when prosecuting the case in trial. First, I will discuss what this process looks like during my initial review, and I'll also be getting into what this process looks like during my second review of disclosure. So in my initial review of the disclosure package, I'm looking for what we have in order to determine what we do not have to request those items accordingly. And during this process, I'm creating a working list of all of the outstanding disclosure. And as I receive more items, I'm going to be coming back to this list to refine what's outstanding and in order to know and what to include for the next disclosure request. So as you see here, this is one of our letters for the disclosure request. And some examples of what disclosure includes are officer notes, book notes, and statements of all the officers that were involved in the matter. I would also be looking to see if these notes are illegible, for example. I'd want to be requesting a copy that's typed up or able to read. I'm also going to be looking at statement videos. So this includes the statement of the defendant, of the alleged complainant, and any witnesses, if any. I'm also going to be checking to see if these files are actually working and playable. They get to be pretty large files, and you want to make sure that the whole file works, for the whole duration of the statement. I also would be transcribing these videos in order to know what was actually said in the statement. And this includes any nonverbal communication, for example, body language. And later on in my second review, I'll be taking a closer look and comparing this written transcript with the statement summary that the officer has provided in order to compare and contrast what was said in the statement versus what the officer has written. Because sometimes there are certain details that are not included, and this can hold bearing to the case. So for example, if the Crown synopsis reflects the statement summary, yet that statement summary doesn't include some important details, you want to know to have those highlighted for yourself. I also would be looking at photos of the injuries, and if there's a medical release form signed, also requesting those medical records. And also surveillance videos that might be available around the scene. You'll be surprised how much a Google search could help you out if you just check on maps. The surrounding scene almost these days, almost every corner is covered by a security footage camera. So having access to those surveillance footage could really help. And lastly, any ICC in-car camera videos, booking videos, 911 calls, and the ICAD report. So that pretty much sums it up for the initial review. And during my second review, this is where I take a closer look at all the details when I review the items. And it's kind of like going through with a fine-tooth comb. And what I try to do is piece a puzzle together and try to place myself actually in the scene by creating a timeline to get a sense of what has happened and how everything transpired. So for example, starting with the photos of the injuries, I would be comparing that with the medical records to examine the injuries and take note to see if there's any signs of physical abuse, whether the injuries are consistent and fits the explanation of how those injuries were caused and sustained, which would be stated in the statement and 911 calls. So just for an example, if the complainant were to say that they were struck in the arm with a bat, I would be looking at the injuries to see if the size, the shape, and the location of the bruising on the arm actually fits the explanation of how they said they got those injuries. I'd also be looking at the officer notes, and this is where I'm creating that timeline. The most important timeline would start with the time that the rights to counsel was given, and also highlighting when the client actually had the chance to place that call to their counsel. There may be times, for example, if the arresting officer didn't actually note the time that the rights to counsel was given, I would cross-reference with the escorting officer who did note that time in order to have a clearer timeline for myself. Another thing that I would look into is, let's say, for example, there's redacted information. For example, in the officer notes, if there's one page of notes that's completely blacked out, redacted, nothing there, and the previous page of the notes is regarding our client, I would be wanting to know why that's redacted. What does it say? So requesting a summary of that information would also help. And going back to what I said earlier about transcribing the statement videos, this is where I compare the different statement summaries to the 911 calls and also to the statement videos in order to see if there's any consistencies or discrepancies. And lastly, I like to play detective, and this really helps when you could check the social media of all the parties involved. This is public information, and you'd want to know what's out there about your client and about the complainants. For example, if they're posting pictures together or if they're clearly contacting one another on social media. It's good to have just to know about that so you can inform your client accordingly. And that pretty much sums up what I do during my disclosure review. And I will now hand it off to Roots.
Thanks very much, Roxana. I'm glad you're a little detective, because I gotta say, being a criminal defense lawyer means you really do have to go searching for kernels of information that you're going to then utilize to begin the process of representing your client. It's not just about getting up in court and making the grand speeches. It's about the preparation that goes into the file well in advance of that ultimate trial date. What you know is that you have, in fact, a set date process, and that set date process is designed specifically to secure disclosure. In getting disclosure and finalizing disclosure, the purpose behind that is to have what will eventually be a Crown pretrial. A Crown pretrial, so that you're aware of, is a meeting between the defense and the Crown. It's to advise them whether or not you have all the relevant disclosure and to tell them what's missing. We're somewhat obligated to have a Crown pretrial. Sometimes those Crown pretrials seem pointless. You get on the phone with the Crown attorney, they're quick, they're fast, they're not really interested. They have 1,000 files to go through. You're just one of the many files. But this is really a fabulous opportunity for you to actually tell the Crown a little bit about your client. And it also gives you an opportunity to find out what the Crown thinks of their own case. Remember, we're talking about, in our test case here, a domestic assault. You know that there's going to be a potential one witness complainant as against your one client. Most of the time, sadly, you'll find that these are male clients and female complainants. But to the extent that they may be married, they may have children, they may be living common law, they may just be boyfriend and girlfriend, there is a history there, and one that you need to be able to present to the Crown at this first opportunity. There may be a family court proceeding in the background that you may want to advise the Crown about, that it's acrimonious as a result. You may want to give the Crown a sense that perhaps their case might not be as strong as they believe it to be. And the purpose behind doing that is because you want to ensure for your client that they're in fact not going to end up with a potential criminal record. In our criminal field, our job is to mitigate loss. Our job is to make sure that the final result is the best result for your client. So I show this to my clients. Usually when I present to them in an interview, I give them an opportunity to understand how the criminal justice system works. So see the line. I don't know if you guys can see the line here. Everything above the line is not a criminal record. Everything below the line is a criminal record. So for example, you've got a client charged with breaking a window. He and his friends were playing baseball, and in the neighborhood, they broke a window, and the old curmudgeon who lives in that house called the police. Now your client is charged with mischief, damage to his property. A Crown, at the stage of the Crown pretrial, may look at this file with some background that you've provided and say, you've got a client who's never been in trouble before. This was an innocent mistake, perhaps paying for the window, perhaps making a charitable donation, perhaps diversion or restitution, and they'll withdraw the charges. Not a criminal record. Then imagine that your client is on the TTC, for example, and he's got his feet up on the seat. And somebody walks by and says, move your feet. And there's a struggle and there's a push and a shove. And all of a sudden the police are called and everybody gets charged. And the Crown will say, you know, this is not a serious offense. I understand your client is going to university. I understand that your client is a wonderful person. I'll offer them a peace bond, not a criminal record. A few months later, your client gets in trouble again. And this time he's on the TTC and he's got his bag sitting next to him and he doesn't move it in a crowded TTC subway. And the person he gets into a fight with this time pushes and shoves him again. But the Crown knows about the prior peace bond because your client's been in trouble before. And the Crown says, you know, he's had a couple of breaks. You know, he's had the diversion and charitable donation in the past. He's had the peace bond in the past. This time, I'm going to be asking for a resolution to the charges, to plead guilty to the assault, but I'm willing to give them an absolute discharge. Now, an absolute discharge is not a criminal record, but it is a finding of guilt. And a finding of guilt will remain on police records for a period of 1 year, an absolute discharge. It means that the police will always have a spotlight on your client for at least a year. And you want to make sure with any one of these where your client doesn't have a criminal record that you make the application on behalf of your client to get their fingerprints and files destroyed at the conclusion of that 1 year on that absolute discharge, at the conclusion of that 12-month peace bond. Because the fingerprints and file being destroyed ensures that your client can apply to jobs, banks, daycares, teachers' college, without having the issue arise that they were once charged in the past. Now, let's say your client is charged with a domestic assault, and this is the test case that we're doing here. A conditional discharge is usually the starting point for a lot of Crown attorneys at the Crown pretrial, or it'll be a suspended sentence with probation, somewhere within this framework. One is not a criminal record, the other is. You want to make sure that you can keep your client above the line of legal destiny. You want to make sure that if you're talking to the Crown and trying to convince them that there is a reason to keep your client from the clutches of a criminal conviction that will last for the rest of their lives, you need to have some information for that Crown pretrial. You need to be able to ensure that you utilize the Crown pretrial to your best advantage. And that means knowing your file. It means knowing your client. It means having the letters of support. It means showing that your client has done counseling, for example. It means showing that your client has made the effort to come forward and accept responsibility, especially if you're resolving based on either an absolute discharge or a conditional discharge. The suspended sentence and probation is exactly the same as that conditional discharge, as I said before, except it is a criminal conviction. A fine is exactly the same as that charitable donation, the restitution or the diversion, but it's a criminal record when it's called a fine. And then, of course, you have custodial sentences, jail, straight time. You get 15 days, you do 15 days. Intermittent, weekends. Your client has a job and can't afford to lose his job, so he gets to go into custody Friday night, comes out Monday morning and goes off to work again. Or a conditional sentence, which is effectively house arrest, which, as you all know, we've been doing for the last year. So this entire process is at your fingertips at a Crown pretrial. You have the power in your hands. You can decide and determine whether or not this matter can stop with a form of resolution without having to go to trial with the best result and outcome for your client, which means not a criminal conviction. There is always a possibility that the Crown won't join you and they'll disagree with you and they won't be willing to go above the line. In which case, you need to speak to your client, because at that point, your client is the one who drives the bus. The client is the one who tells you, no, Roots, I want to go to trial. I want my day in court. Get written instructions. Or the client says to you, I'm okay if I get a suspended sentence with probation, a criminal conviction. Get written instructions. Or the client says, I refuse to sign a peace bond. I don't care if they're offering me a peace bond. I want to go to trial. Get their written instructions. It's imperative that you do, because if you don't, it can cause significant problems for you personally down the line. What you want to do is CYA, cover your ass. Now, if the client doesn't want to resolve, you have to then deal with potentially setting this matter down for trial. And depending on the length of time that's going to be given to this trial, and depending on the jurisdiction in which you're at, If it's more than 4 hours, some jurisdictions will require you to have what's called a judicial pretrial. A judicial pretrial is a meeting basically for the judge, the Crown, and the defense. It's really your second kick at the can in trying to convince the Crown to stay above the line in the line of destiny. The judge who is really overseeing this judicial pretrial is trying to do so by ensuring that the best use of the court's resources are used. And perhaps in this particular circumstance, this domestic, where your clients may have already done upfront counseling, a judge is going to be on your side, pushing the Crown, needling the Crown. Crown, maybe you want to change your position. The defense has done everything here. Crown, maybe you'd want to agree to a peace bond. And it's their opportunity for a judge to put some pressure on the Crown. Sometimes it works the opposite way. It puts pressure on the defense. But in most cases, the end goal is to resolve without setting the matter down for trial. Because as you all know, trials are expensive. Setting up a courtroom with clerks, court officers, the lighting, the heat, if there's never any heat at Old City Hall, but all of those things costs. The cost of the Crown, the cost of the judge. Think about the economics. You'll find yourself surprised to understand that the route to resolution is a lot easier than you are given any notice of. But the judicial pretrial is quite important. And in order to be ready at the judicial pretrial, you need to know your file. You need to know what sort of applications you're going to be bringing. You need to know that you're actually going to be cross-examining a complainant who might want to be cross-examined behind a screen. You may want a support person. You need to be aware of all of these features so that you can get ready for trial and bring the appropriate applications. And to that extent, I now turn this presentation over to my other junior counsel, Serena Kojikaru, who has prepared a presentation on applications. She is the go-to application girl in our office. She seems to win a lot of the Garofoli applications these days, and she has a handle on when and why and how to file them. Serena?
Thank you, Ruth. Now I'm following a PowerPoint presentation, so I do apologize. It will not be as amazing and as exciting, but let's start with what type of applications you might have to file in a domestic setting in this case study. Now, one of the applications you might have to deal with is something that's called a voluntariness application. This is where a Crown is seeking to enter a statement or an utterance that was made by your client. And it's the Crown's burden. They're the ones who have to prove it. They have to prove it on a balance of probabilities. But we have to show that we would have to show that the statement was not voluntary. Now, let me give you an example of two types of forms that this can take. The first, it can be an utterance that was given before any rights to counsel are given. So your client yells at the officer before the officers had time to give him rights to counsel, "I didn't hit her, I just slapped her." Well, now they have a confession to an assault that you now have to deal with. And as Ms. Seymour has mentioned, this is why rights to counsel are so paramount. Now, the second form that a statement can take is one where rights to counsel have been given, the client has been taken to the station, and they're placed in an interview room. This is usually an audio and video recorded room, and you would get that video, and you would get that. Now, what does it mean if a statement is involuntary? First of all, it can't be coerced in any form. It does not involve any threats or promises. It's not the product of any leading questions. And there's absolutely no other form of investigatory misconduct. Now, a prime example of when a statement might not be voluntary is when your client is completely drunk. they're so inebriated that they would not be able to make any statement voluntary. They can't appreciate the jeopardy that they're putting themselves into. So in that instance, you would argue that the statement itself was involuntary. And for that, you need that disclosure. You need to be on top of it, and you need to go through it with a fine-tuned comb. The interview video, no better way to tell whether or not that statement is voluntary. Look at how your client's acting. Look at how his speech is. How is he interacting with the officer? If you can tell that he is drunk, that officer should have known too. The second piece of disclosure that you want to look at, the booking video. Again, how does your client present? Is he being held up by two officers? Is he wobbling? Is he able to walk straight? The other thing is, in the booking video, the booking sergeant always asks if that individual has been drinking. So if he's saying that he did, that's another thing for you to keep in mind. The other thing is the officer's notebooks. Read through those notebooks and see, are there any signs of the term HBD, has been drinking, in any of those officer notebooks? They're the first ones that they're interacting with the client. So they would put that in. The other thing is signs of inebriation. Do you see anything in those notebooks that says he had slurred speech, he smelled of alcohol, his eyes were glossy? All of these are paramount to a voluntariness issue. Another thing, the in-car camera. Now, if you're working in a jurisdiction that actually has in-car cameras, request that. Make sure that you know what's happening with your client from the first moment that you can. And finally, talk to your client. Get his recollection of what happened. How did he feel during the interview? Was there more to the interview? Say you get something that's 1 hour long, but your client tells you he was in there for 3 hours with the officers. At that point, something's up. You need to make sure that you know his side of the story. Because if the client was in the room for 3 hours and it was only being recorded for 1, the officers could have been trying to get him to say something that they shouldn't have. They could have been doing one of the things that makes a statement involuntary. They could have been coercing him. They could have been making threats or promises. All it takes is for an officer to say, hey, tell me what happened. I can get you out of here. I can help you. Officers can lie. They're allowed to. And if your client did not listen to you or to their counsel when you gave them the advice to shut up, that's going to make your job a lot more difficult. Now, another application that you might have to deal with is third-party records. Think of a situation in which the complainant and the client are in a relationship, and there's family court documents. Now, whatever is filed in family court could also be used, but the thing is, if you want those documents, you have to make an application for it. And this can take a while. Always make sure that you know your filing deadlines. It does take a while for a third-party application to come through. Remember, you're not just now dealing with the Crown Counsel, you're now dealing with whoever has possession of those third-party records, as well as the complainant, because they also get a copy of that application, and they would have a lawyer who would be asserting privacy interest in those documents. Now, the most important part of applications is obviously being prepared. You need to know what type of applications you'll be bringing before you even go into the JPT stage. Because chances are you're going to be asked by the judge if there are any pretrial motions that you need to bring. This means being on top of your disclosure. If you don't have it, ask for it again and again and again until you either get it or they give you an answer telling you that it doesn't exist. And quite honestly, sometimes you may have to ask for it again if you know that there's something that should be there. Because the last thing that you want to do is get told by a judge, why did you not ask for this piece of disclosure if it's so important? Now, with your applications, These all prepare you for the trial setting. So make sure you know what you need to bring, make sure you file them on time, and make sure you prep for that trial. Thank you.
Thanks very much, Serena. It's always great to hear how your process in determining if applications exist works. It's also great to hear your dog in the background. I can see that Shiro is having a bit of a bark at your comments. Now, one of the things that I posted up on our screen was a document that we call Always Be Prepared. And I just want to make sure that everybody understood what that was. I'm just going to pull it back up again. This is what is in the Form 17 for Superior Court. And what I mean by that is that in Superior Court, when you're getting ready for a JPT in Superior Court, there's a document called a Form 17. You can actually get it off the government website under Form 17. Do that, because what this form does is it goes through everything that you need to know about your file before you walk into a judicial pretrial. But it also goes into, for example, pretrial motions, whether they're Crown pretrial motions or defense pretrial motions. And as Serena was indicating, one of the areas that you're going to be touching on potentially is a statement. Is the Crown seeking to obtain rulings as to the admissibility of statements to persons in authority? And in so giving that statement, how is that statement going to be admitted into the case? So if your client doesn't listen to Paula to keep his mouth shut and then starts to blab, how are you to deal with that? Is it a statement recipient as a person in authority? Is it a voluntariness issue? Is there a 10A charter violation? Is there a 10B charter violation? Or is it a Section 7 right to silence violation? These are all great questions to ask yourself. And rather than reinventing the wheel, use what we have. We have these Form 17s in the government website. We keep a copy and we just literally use them as our checkbox, so we can actually determine whether or not we need the transcripts for a document, whether or not there's a principled exception to a hearsay rule. We can talk about other issues. For example, if it's going to be a voir dire, is there after the fact conduct? Now, you may not have any of these issues arise for you, but it's always good to find out. Is your complainant going to utilize a support person? How does the Crown intend on letting them testify? Is it going to be behind a screen? Are there going to be publication bans? Is there going to be a publication ban that you would like to see requested? Remember one thing, we're in the age of Zoom and technology. It's easy for anybody to jump on a Zoom call and watch the court proceedings, and we don't know what's being recorded. You need to be careful to protect your client's rights. Make sure that you ask for publication bans. Then there might be evidence that needs to be excluded, but those are different cases. So just keep in mind what options you have available. Go through the checklist for yourself. And when you go through that checklist, it makes you far more prepared to step into that judicial pretrial, tell the judge exactly what this trial is going to look like. And so when you go to trial, you're ready. And Thakshini is going to take you to trial now. And Thakshini, by the way, I should give an introduction, shouldn't I, Thakshini? Thakshini is the newest member of the Roots of Law team. Other than Roxana, of course, but Thakshini joined my firm. She's got significant background, peeps. She did a stint in New York and has run jury trials and trials as a public defender out there. So I am grateful that she's joined our team. She brings a certain eloquence to our firm, and I'm very happy to have her join us here to do this presentation.
Well, thank you very much, Ruth. That's very sweet of you. So I'm going to be talking to you about the trial. And now that you've been thinking about your game plan for this trial for months and months, it's time to narrow the issues and prepare your materials for trial. So this is definitely something you can talk about for hours, but I'm going to streamline this into 5 tips to keep in mind when you start preparing for your first few trials. The first tip would be to know your disclosure. one of the most important ways to prepare for trials is to know the disclosure better than anybody else in the room. You need to know what each officer says, how they might differ from each other, what each witness says, if they give multiple statements, are there inconsistency between those statements? And maybe you'll be able to review that disclosure once or twice and commit everything to memory. But personally, I have the worst memory ever. I would never be able to remember all that information. So one tool that I use is to make charts, to organize the disclosure in a way that makes sense for my trial preparation. So for example, if we're talking about domestic assault, if there are 3 officers that show up for an arrest at an apartment and they all say slightly different things from each other about the different evidence that they're going to give, you can turn it into a chart. You can have the officers 1, 2, and 3 on one side, and you can divide the information. What do all 3 officers say about the state of the apartment? What did they say about the injuries that they observe? What did they say about the statements that are made, the evidence that's found? Where is the evidence found? And you can organize that information into a chart, which one helps you with reviewing the disclosure again and helps you review exactly who says what. But 2, when you're done with all of that, you have this tool. You have a chart that concisely and organized creates an organized table for you to have all that information at your fingertips during the trial. And that way, when these officers are testifying during trial, you're not frantically flipping through the pages looking for where was the notes where he said this thing. You have it all prepared in a chart ready to go. And that's really important because trials happen very quickly. As soon as a witness finishes direct examination with the Crown, you're going to be up to bat. You don't often have that much time to stop and organize yourself and organize your notes. You might have a few minutes, and if you get lucky, the Crown might finish right before a break, but sometimes you'll have to go right away. And if you have the tools ready to begin your cross-examination, then you're the more efficient lawyer, and that only helps your cross-examination be more organized and more efficient. So you want to take the time to create those tools before you even get to trial, because they'll really be very useful while you're in the middle of cross-examination. The second tip that I have is to draw out inconsistencies. So if you know your disclosure better than anybody else, you will also know when a witness testifies to something that's different from what was in your disclosure. If a witness gives a statement to the police, or if the police make notes of something and then they say something different on the stand, you're going to know because you know that disclosure in and out. And when you have those inconsistencies, it's important to draw that out for the judge because you want to make those witnesses look less credible. You want to show the judge that the witness is lying, and because he's lying today, you can't believe anything that he's saying. So in order to do that, you want to impeach the witness. And you impeach a witness by doing 3 things. First, you want to repeat and confirm the statement. So you can say, is it your testimony today that he punched you for the first time outside of the apartment? And the second thing you want to do is you want to ask the witness about the previous statement. You want to say, you remember giving a statement to the police on March 3rd. You gave that statement at the police station. You were under oath at that time. You swore to tell the truth. And you want to build up the importance of the statement. So you want to say you understood you were helping with an investigation. You understood that the police were going to take what you were saying and build up the case against the accused. And then the third thing you want to do is you want to ask them, and at that time, you told the police that, for example, he punched you for the first time in the kitchen inside the apartment. So what you've done here is not only show that the witness gave 2 versions of the same evidence. He said he was inside on one occasion and that he was outside on the other occasion. You've also built up the prior statement to be just as important as what he's now said in court. So you want to make sure you don't give the witness any wiggle room to now say, oh, I didn't really mean it when I said it at the police station, or I didn't think it was that important. You've made it clear that prior statement was just as important. You were under oath, you swore to tell the truth, you understood the importance, and now you're making sure that the witness can't minimize the impact of that inconsistency. And you're demonstrating to the judge that he's given inconsistent statements, and you'll now use that at closing to tell the judge, you shouldn't believe this witness. This witness is capable of lying. He's lied before. We don't know when he's going to lie again, and we don't know what part of his testimony we can really believe. And that's obviously very crucial for your closing argument when you're trying to convince the judge that the testimonial evidence that they're hearing should not be believed, and you should be finding a verdict of not guilty. And so speaking of closing, that's my next tip, which is to work on your closing first. So it might seem like you want to save your closing for the end once you've figured out everything else. But an interesting technique is to do your closing first. It helps you map out all of your arguments, and that way you'll know exactly what points you need to hit. So when you're writing out your closing, you want to organize it to make sure you're explaining why the Crown has failed to prove their case beyond a reasonable doubt as to each element of each crime that your client is accused of. So this also helps you think about, well, what are the elements that the Crown has to prove? What evidence are they going to use to prove their case? And what are your lines of attack for trying to pick apart their case? And how are you going to do that? So when you're writing out your closing, you're creating a roadmap of exactly what your lines of attack are, exactly how you're going to attack each element, and what evidence do you need to make your points. So it's kind of like writing an essay. When you're writing an essay, you do all sorts of research and you have all these citations that you're going to include. You wouldn't submit your essay without showing your professor what sources you used. And in the same way, you can't make a closing argument without using the evidence that came from the trial. Even if you wanted a witness to say something and he didn't end up saying it at trial, you can't use that at closing now. You have to use what actually happened at the trial. So it's important to know exactly what you need. It's kind of like a to-do list or a roadmap of exactly what you need to come out at trial. And that way you can stay focused, you can stay on track, and you can make sure you don't miss anything. You can even have little boxes where you can check it off as you're going along throughout the trial. So you know exactly what you need from each witness. And that leads to my fourth tip, which is to plan how you're going to stay organized during the trial. If you have a roadmap of what you need, then the next thing to do is to know how you're going to organize all of the testimony and all of the evidence you're going to hear. Because each witness has a lot of information that they're going to bring, and it all happens very quickly. So you want to make sure you come up with a way, probably beforehand, that you're going to keep everything organized. So when I was watching Roots do a murder trial earlier this year before COVID, I watched that her technique was every time a witness starts testifying, she takes a piece of paper and draws a line vertically down the middle. And on one side, she writes down what the witness is saying on direct. And every time she wants to use something that they're saying on cross, she'll draw a little arrow to the other blank column, and she'll write a note like, this was different from what they said at the police station. This is something they've never said before. And so it helps her organize what are areas of cross that she now needs to address based on what she's hearing. But in addition to this, you also want to write out a lot of your cross before the trial based on what you already know. So based on the complainant statements that you get, based on the police notes, there's a lot of the trial that's going to be predictable and that you can figure out your cross-examination well before the trial starts. And that's an important technique because during the trial, there's a lot going on. You're listening to the testimony, you're thinking about your objections, you're thinking about your cross-examination, you're addressing issues from the judge as they may arise. If you can take out some of the legwork, take out some of your brain work during the trial and have chunks of your cross that are already written out based on things that you know it's not really going to change much, that's a piece of work that you don't have to do at the trial now. You've already got that ready to go, and you can focus now on the curveballs that you're getting and the unexpected testimony that you're getting. And it's important and it's useful to do that in the comfort of your home, and it helps you game plan a little. It helps you get an idea of what is this cross going to feel like? Am I going to be aggressive during this cross? Is this a nice guy cross? You can practice in front of the mirror. It's good to take that time to really put that planning in beforehand in the areas that you can. But while you are writing a script, it's important to remember not to remain too attached to that script. It gets really comfortable reading off a piece of paper, especially when you're nervous. So you want to make sure, even though you have a script, you're prepared to go off script. You want to listen to what the witness is saying. You want to reflect and respond accordingly. So for example, if you want a witness to say yes, and they say sometimes, maybe that's something you can let go. But if that yes was really important to your case and your closing, you have to dig in a little deeper. You have to ask follow-up questions and think about, what evidence do I have? What information do I have to attack this answer now to get what I need from this witness? But if you're robotically just going through your questions, you're going to miss that he even said sometimes. So you have to be really intuitive thinking and intuitive listening. So you're really listening to what they're saying and responding accordingly. And another thing that you have to prepare is applications that the Crown might give you. So something like a 9-2 application where the Crown's own witness is saying something different than the testimony that they gave in a prior statement. And now the Crown wants to question them on that prior statement. So there's a procedure that has to be followed if that's going to happen. And the Crown has to meet a certain burden, and there's a standard that needs to be met. So you need to understand the law on these types of Crown applications so that you can respond accordingly. And knowing the law gives you the tools in these cases. When things aren't going according to plan, you need to know what the law is. It's a really good idea to have a criminal code with you because if there's something you didn't anticipate, at least you can look up the number that everybody's talking about and learn it on the spot so you know what tools you have to solve the issue that's going on right in front of you. So as you can see on the slide, another aspect of preparation is putting your client on the stand. So obviously, as part of the defense, you always have the client has a right to testify, but it's a strategic decision that you have to make with your client. Putting him on the stand to testify, to tell his version of the events might sound like a great idea, but you also have to consider that that means the Crown will be able to cross-examine him. And there might be pitfalls in that. There might be aspects of his story that might lead to guilty counts because he's willing to admit to some parts, but not other parts. And in putting him on the stand to testify, you have to think about how all of that's going to look on a cross-examination. It takes a lot of preparation because you really have to, people aren't used to being cross-examined, and clients are obviously very emotional about their own case as it's happening, and you have to prepare them. And that's why it's great to have a firm full of other lawyers as well and other people you can ask to practice with them. So you can have someone practice cross-examining your witness. And if you choose not to have them testify or to have them testify, it's important to get written instructions so that the client can't turn around another day in the future and say, I really wanted to testify and my lawyer wouldn't let me and she said I wasn't allowed to. That can't be the case. It has to be that there's written instructions that clearly indicate it was a decision that you both came to together. And he understood all of his rights before he made that decision. So the last tip that I have is figuring out your style. For a lot of people, public speaking and questioning witnesses and being aggressive and speaking on your feet, these are difficult skills to master. And it might not come naturally for you, but at the end of the day, it's a skill. You can study it, you can read books, you can watch videos, you can watch other lawyers, and then you have to practice it. So I remember when I was working as a law clerk and I would get to do set date appearances, I was a nervous wreck. I would have knots in my stomach. I would write down everything on a piece of paper, including my name, just in case. My hand would be shaking as I'd be going up to do my little spiel on the record. And I would just be a nervous wreck about it. And I went somehow from that version of me to the version of me that can do trials. And the only advice I can give you about how to go from point A to point B is to keep doing it. Keep putting yourself in courtrooms, take every opportunity you can to speak in court, because the more often that you do it, the easier it becomes. The less nervous you get, the more comfortable you get in that space. It's definitely a daunting arena to be in. The natural, just the courtroom acoustics, and when you're speaking, you're the only one that's speaking, you can hear yourself talk. It's very awkward, but you get more and more used to it the more often you practice. So take every opportunity you can, especially with set dates, because there's small little appearances. You're only speaking for a few minutes, so it's a good way to practice. And there's nothing wrong with picking up on different people's styles. It's a good idea to get to set dates a little early so you can watch other people do their thing and see their style and watch what kind of language they're using. And a lot of it's just imitation. Just copy what you feel comfortable with. It's not just about being yourself, but it's about being comfortable with the style that you're choosing. Do you feel comfortable in this skin? A lot of it's faking it till you make it and practicing 100 times beforehand at home and just being as comfortable as you can so that no one really knows that you're faking it. And I think with all those tips, you'll be at a good starting position to do your first few trials. And if ever you have any questions, feel free to ask us. We're more than happy to help.
You know, Dakshini always makes it look effortless. You'd never know, really, with her. And I have to say, even after 25 years of doing this, I still get butterflies in my stomach. And I think the edge is also good because it keeps you fast and on your toes. But this is one of the most exciting professions for me, and I know for the ladies who are in this office with me. We love this work. And if you love the work that you're doing, it'll be a joy to do every single day. I hope you enjoyed our presentation. We enjoyed giving it to you. I believe we're opening up the floor to questions.
Perfect. Thank you all so much for such a wonderful presentation. I think it's certainly going to make teaching the rest of the course a lot easier because it was such a perfect, compact way of going through various steps in the process. The one thing maybe, I don't know who would be okay with touching on it, is what happens after the trial is over. And let's say, perhaps you don't necessarily get the result your client is hoping for, and it has to proceed to sentencing. And certainly you've Roots talked about the different things that you can ask for in terms of absolute discharge, conditional discharges, all the way up to incarceration there. But maybe what goes into preparing for the sentencing to get something like that. And I know one of the students, because they have an assignment, so they were trying to be sneaky about it, and I caught on to it. But if there is a client that has addiction issues and you're looking for the best possible resolution for them, what goes into preparing for either, maybe you're lucky enough, especially right now, you're seeing maybe more crowns looking at it and saying, hey, yeah, maybe this is something that we can divert altogether. Or if it goes to trial and it ends up with a guilty result, how you can minimize the impact on that particular client.
Perhaps I'll start by saying that's the one area that I failed to include in our presentation, partially because we're so eternally hopeful of getting good results for our clients and winning that we never think about sentencing until that day actually dawns on us. But the truth of the matter is that a trial is like playing Russian roulette. Your real power comes at the Crown pretrial or the judicial pretrial stage when you have control over the file. If you truly believe the matter is heading towards resolution, don't play or gamble. Sometimes you can gamble, but don't do it all the time. Don't take it to trial. If, however, you end up taking it to trial and the witness actually shows up and testifies and sobs a good story, and you can't get past her evidence and your client is convicted, then you need to be ready for that sentencing hearing. And as a judge once said to me when my client was convicted and I said, I'm not ready for sentencing, he said, you should always be ready for sentencing, regardless, even if you got a great case. So one of the things that the office does is we prepare letters in our office. We get family members, employers, church group, community leaders, psychiatrists, psychologists, counselors to write letters about our client. And we have a collection of those letters in our arsenal of materials in our file. The best result would be to ask for the adjournment so that you can put together a sentencing book. All our sentences, even the ones that we've planned out in advance, all come with a sentencing book. We file materials in advance. We file a mini factum to go into the background of our client. We provide all of the letters in that bound volume, inclusive of any documents, medical records, et cetera, that we can then provide not only to the bench, but also to the Crown. And to make our position well known, we add in our cases, speaking to the range of a sentence that client may find themselves within. The range of sentencing can vary depending on the offenses, but when you're looking at, for example, a domestic assault where you've got a first-time offender and the injuries are minor, you can see yourself to getting that client potentially that absolute discharge, especially if, for example, the client may have ties to the United States, whether work or familial. And in those circumstances, you want to make sure that the client can actually travel to the United States. You don't want that conditional discharge. You want the absolute. So you have to plan all of that. And there are cases that'll help your position. It's always best to have that material on standby. It's always best to keep a precedent file in your office for the various types of applications, including sentencing.
Perfect. Thanks for that. And I think that's a very important to have all of that, because at the end of the day, the more information you have about knowing the client, as much as there's law and stuff, it's about looking at this person and deciding based on what's there, what's the outcome going to be. So let's go through maybe what I'll do is go back through from the beginning there and maybe have a question for everybody. So I did see something a bit before there. I think it was from Kevin, and this is for you, Paula, about what can the police do? Certainly, once you start saying, no, my lawyer said not to say anything, does that mean the police just stop altogether with questions? What can they do to kind of convince your clients? And I work actually as telephone duty counsel, so I deal with this all the time, where I find out later on, from counsel who takes the case, that the police offer them a cigarette if they start talking, and lo and behold, that must have been the most. I don't smoke, so maybe I don't know the value there at the situation, but then they start talking. So how can you better tell clients, like, look, this is what's going to happen, and get them to hold the company line, so to speak, of the lawyer told me not to say anything?
All right. So just so I'm clear, I take it Kevin's question is, even if I told the officer I don't want to speak, he's still pressuring me to speak anyway. And I think you said earlier that, I see it just popped up, yes, on the chat group. Okay, so even if police will still try to pressure your client, there's unfortunately nothing you can do to stop the officer from doing that. So all you have to do is just repeat it. So I tell clients that, as I said earlier, when I do a role play, I will tell, even if you feel weird, saying it over and over again, say it. If you feel like you have to say something because it's just bizarre just sitting there staring at somebody as they're yapping at you, still just say, my lawyer said not to say anything. My lawyer said not to say anything. My lawyer said not to say anything. Do you have a cat? My lawyer said not to say anything. Is that your car? My lawyer said not to say anything. Is that your daughter? My lawyer said not to say anything. Were you there last night? My lawyer said not to say anything. It feels weird to say that, but this is how you emphasize to your client how you exercise your right to silence. Officers will try to trick you. They will try to lie to you. They're allowed to do that. They can say, look, I know your lawyer said not to say anything, but look, if you just tell us if you were there last night, we just want to make sure it was you there. Because if you weren't there, then, we'll just let you go. Don't answer that. That's just their trick to get you to say something. Don't think that you can ever talk your way out of it, because you don't know what lie they're trying to fashion around you. You don't know all the circumstances. They are going to tell you everything about what was said about you. They don't have to. So rather than taking that risk, you just say nothing at all. So that's what you would need to tell your client. Look, you've got to enforce your right to silence. My lawyer said, blame the lawyer. That's what I tell clients too. I said, just blame me. Blame me. If you feel uncomfortable, just say, blame me. Just blame me, blame the lawyer. Say, my lawyer said not to say anything. My lawyer, Paula Seymour, she said not to say anything. And I expect that an officer officers hopefully will just give up and say, you know what? We can't milk anything out of this guy. We're just not going to bother. I don't care. And I tell clients this, I don't care if they're trying to beat it out of you. I don't care if they try to feed you food. I don't care if they're trying to, if they're saying, well, you know what? So-and-so said this about you. Sometimes they do that in order to see how you respond, in order to get a certain reaction out of you to see, if you're lying or you're telling the truth. Play poker face. If you don't know how to play poker, just say, my lawyer said not to say anything. right? Don't lie, don't tell the truth. My lawyer said not to say anything, okay?
One of the
I'll-
things, if I can just interrupt at this
Mhm.
point, is that, clients seem to think that the police are there to assist them, that they're going
Right.
to help them, because we've had this ingrained belief that the police are there to serve the community and that they're there to help us. In the circumstance of being arrested in a police station and facing charges, they are not your friends. They are not your advisors. And my line to clients is always, other than telling them on the advice of counsel, I have nothing to say, and taking them through the role play that Paula referenced, is to think of it this way. If you were a pig, would you go to the butcher for advice? Not likely. Do not say anything. Exercise your right to silence. It will save you heartache down the road, and it'll cost you less, because those voluntariness applications and those charter applications to get that statement excluded, cha-ching, that's how we get paid. So don't waste your money. Every word that comes out of your mouth is $1. Just think of it that way. Maybe it'll save you the hassle of actually making a statement then.
Perfect. Thank you both of you for explaining that, and hopefully that answered your question there, Kevin. Paul, another thing then, if it gets to an actual bail hearing and they're not going to release your client, and you talk quite a bit about sureties, what are some characteristics, or what are some things to look at in terms of satisfying, maybe if the Crown, maybe let's say it's an issue of secondary grounds, that they believe maybe your client is going to call up, using the example we were looking at domestic violence, maybe they're going to have contact. They're going to, as soon as they get out, they're going to pick up the phone and try to reach out or show up to their girlfriend or ex-girlfriend's house. What can you do, and who can you bring as sureties that will alleviate those concerns from the Crown? I mean, either if you maybe get them to consent to the release, or even if you have to go and argue for it before a justice of the peace.
All right, so if your client has a close friend, let's say, for example, that knows the girlfriend, that person, or even a family member, those people are in a position to say, yes, I know that girlfriend, I know where she lives, I know where she works, I know what she even looks like. So I know who he's not supposed to be around, in order to make sure that he complies. So the surety in that respect can give confidence to the Crown that he'll comply with that condition, because they know how to exercise that. So for example, if the client is walking down the street with the surety and a woman approaches, he or she knows, oh, that's the girl that he's not supposed to be around, let's walk away. And now I'm going on the basis of whether there is if there is going to be a consent release, because you mentioned earlier about if the person is detained. And I hope I didn't misunderstand you there, but if, when it comes to secondary grounds and any concerns of recidivism, that has to do with whether that person has demonstrated a history of not complying with those bail conditions. But again, in my view, if a surety has a strong and strict plan of supervision to make sure that he complies. So for example, these days, I mean, technology is awesome these days. Now, even if a surety is going to work and they want to make sure that that the client is home where they're supposed to be, or at work where they're supposed to be, all you have to do is video chat them and you can see, exactly where they are, that they are at home, or they are at work, that they're not where they're supposed to be. People have video cameras on their homes, so they can see who's coming in and out of their home, to make sure that that complainant or the alleged complainant is not coming by. Because sometimes you have in domestic situations where the girlfriend or the wife, they want contact with the husband or the boyfriend. And they don't care about the conditions. They just want to do that anyways. But the problem with that is they're putting your client at risk of getting arrested. It doesn't matter that they want to see your client. Court doesn't care about that. They could be banging on the door. Your client cannot open the door for that complainant to come in. Neither can the surety. But that's how a surety can give confidence to the Crown and ultimately to the court that he or she can make sure that the client complies and that there's not going to be recidivism. I'd say, again, it also has to do with the relationship. The surety has to demonstrate that that person can be trusted, that person can be in a position of authority to that client, to make sure that that when the surety tells them to do something, they do it. That goes back to what I said earlier about a surety kind of being like a jailer, that if they're telling you to follow the rules, that you're going to do it. And if you don't, they're going to just, call the police and just send them to jail. That's also a part of how a surety can make sure that, or demonstrate to the court and to the Crown that they will make sure your client complies. And then on top of that, your client has a relationship such that they're not going to just, ignore whatever the surety says. They will listen and they will take that person seriously, particularly based on the historical relationship that they've had.
Perfect. Thank you so much, Paula. The next phase then we went on to was talking about disclosure. And let's say you're missing some information and you're not sure if the information you're going to get is going to maybe help or possibly hurt your case. And maybe the Crown hasn't turned their mind to surveillance videos or something that'll put your client at the scene of the incident. Is it better to ask for all of these things and know things up front, or tactically just they didn't bring it up, let's leave it be and hope it doesn't come up at trial? So I don't know, Roots, if you want to address that, or Roxana, maybe you've had to deal with something like that.
Well, I can tell you that Roxana alerts me. That's the beauty of having Roxana as a disclosure clerk. She actually alerts me that this is a location where there might be surveillance camera, for example, at a corner Tim Hortons, for example. And by alerting me in the disclosure, we have to make that tactical decision, because you need to know whether or not this is the type of material that you're going to subpoena, that you're going to try to get for yourself. Maybe it's a camera that is in a private residence and you can ask that individual, can I see the camera, before you let the police know about it. Getting our own access to evidence, whether it's surveillance videos, text messages as between our client and the complainant, photographs as between the client and the complainant. There's a wealth of information that you can secure without having to alert the Crown Attorney about it. There's always going to be times where the police have also done their due diligence, and they've secured that surveillance camera from that corner Tim Hortons. And it may not be favorable to you. But as I tell the group, and as we discussed this afternoon when preparation for this, it's better to know up front what you're dealing with than to be caught off guard or lying in the weeds thinking that somehow the Crown has missed it. Trust me, if they have evidence that's going to help them convict your client, they're going to use it. It's better to know about it and to be able to plan around it than it is to hide from it.
Thanks for that as well. And I think then we were talking about applications, and let's use maybe the domestic violence situation where there's an assault charge or mischief or something like that. But let's say assault, and your client comes to you and says, look, I know they're making it up. I know they went to the doctor before and they had this black eye from somebody else a couple of weeks ago, and they're now saying it was me that did it because we had a fight, and they went to the police and I got charged. In terms of getting a third party, or it could be a phone record or something as well, a third party records application. And I guess this question is for you, Serena. How can you get that information? Because it's kind of like they don't want a fishing expedition, right? But you don't necessarily know what's there unless you see it. So how do you kind of balance that? Hey, we know that there's something there, but we can't really say it until we see the record to get that information into your hands so that you can bring it up there as part of preparation for trial.
So for that one in particular, I'll start with the example that you gave with medical records. That's something that the client tells you about, and if he knows that it's true, it gets to the point where you need to trust your client. You need to trust that they're telling you something that will help you, and at that point, it has to be that, okay, if you know for a fact that this individual was actually punched before, then that's when you start making that third record application, going to the hospital, serving them, and getting the information that you need. It always is, like Reitz has mentioned, it's a double-edged sword. You might get something that you don't want to get, but you might also get the one thing that might get your client off and prove that he or she is innocent in that regard. So if it is something that is crucial and you've had that discussion with the client, it's something that you need to pursue. And as everyone has said, all of this gets done in writing. You speak with the client in regards to what are the costs for this application. If it's a private client, if it's legal aid, you would still have the discussion to let them know if this comes back as something being detrimental, you need to know. And you need to be the one that's saying, yes, I want to go forward. I'm putting my trust in you. Please get me these documents. Because it's not going to be as simple as just going to the hospital and saying, hey, on March 12th, that so-and-so came here and I need her medical records. Because again, it's a privacy issue. No hospital record is going to just give you some medical documents for an individual, even if they are husband and wife, unless they have a signed power of attorney, which at that point, realistically, they wouldn't. No hospital is going to be giving you private information. So third party.
You're going to have to subpoena it, right? And that's the rub in all of this, is that in order to get this third party records application served and filed into a court, you need the documents that you're trying to secure subpoenaed into court. And once they're subpoenaed into court, there is a two-step process to determine whether or not, in fact, the records are necessary, if they're reliable, and if, in fact, the use of those records is going to be one that is necessary for the defense to have access to. There's a second component to this, and for defense lawyers, it can be really difficult to grasp that this is a privacy interest to the complainant. We're asking for her medical records. We're asking for her personal space being violated, and he has, the complainant has the right to protect that interest, but not at the exclusion of making full answer in defense, which is constitutionally enshrined in the charter for the defendant. What we do know is that in making that application, we're obligated to serve everyone who it affects. So the complainant's lawyer gets access to that third-party records application. In proving why we need it, we're obligated, unfortunately, to spell out what we believe is going to be in the records, right? And sometimes that's where the clash really happens, because it's like a reverse disclosure obligation from the defense to now the Crown and potentially the complainant's lawyer. But remember one thing that always kind of comes up in these cases: just because we're giving our materials to the complainant's lawyer doesn't mean that the complainant's lawyer gets to share it with their client. So to protect the integrity of the process, there are in fact what these artificial walls that are kind of put up in order to determine the issue of whether or not this record is one that is necessary for the defense to make full answer, but also whether or not it's one that can be outweighed, outweighing the prejudice that would be occasioned to the complainant in having her privacy violated. So there's always a balancing act, and at the end of the day, it's the judge that makes that call. But you have to file your materials and be ready for that application. And you need to let the judges know at the judicial pretrial that you're bringing it, because a separate day needs to be set for third-party records application in advance of the trial. So don't get caught behind the 8 ball and not have your materials filed.
And then finally, we were looking at, and thanks for sharing that. Finally, we're looking at trials there. And Thakshini was talking about maybe you're going to call your client, maybe you're not. And I see a question here. A student was wondering, could you just have a client swear an affidavit to whatever they want to talk about and then not put them up on the stand? Or alternatively, when is that decision? When do you have a do you have a deadline? Do you have to declare that to the Crown before trial, or can you decide, hey, this trial is not going so well, maybe we need to put our client on? Is there a deadline before you make a decision whether to call or not to call them?
So in terms of an affidavit, unfortunately, you cannot serve an affidavit. You have to, if your client is going to say anything, he then opens himself up to cross-examination. So it's not, you can't just have it be a one-sided story. And in terms of the timing of that decision, the nice thing is that that's not something you need to disclose until the end of the Crown's case. So you really can't, it shouldn't be a decision that you wait for that point to make. You should really be making that decision beforehand, because it takes a lot of preparation to get your client prepped for trial. But you don't need to tell anybody that he's going to testify or he's thinking about testifying or anything like that until the Crown's finished their case. So you really can assess how things are going and make your decision based on that.
And maybe the last question here for you, talking about trials now and set dates and applications and everything in the Zoom era, how have you found in terms of advocacy and assessing credibility of witnesses when you see from the shoulders up sometimes, and who knows where they could even be? What challenges does that pose in terms of preparing for trial? And something probably you never learned in school ever, because we never anticipated a virtual criminal hearing, a criminal trial back in law school.
I think it's been very interesting trying to adjust. I think, in terms of set dates, that's a great thing to have on Zoom court. You save yourself lots of driving time and parking meters and all that stuff. But in terms of a trial, it's very interesting. Obviously the client always has the right to be in court, but then you get applications that say the complainant wants to testify at home, or if she testifies in court, she wants to keep her mask on. So now you have to balance out what's better and what's worse. Do I want her in person where I can see her more completely, but she's wearing a mask? What does that mean for covering her facial expressions and the difficulties of hearing her speak? You're wearing a mask, there's plexiglass everywhere, versus Zoom court, where you have a lot of difficulties knowing where they are, who else is in the room, what materials do they have at their fingertips. Even I right now have my presentation notes next to my Zoom screen, and no one would be the wiser of that. So it's a lot of difficulties. It's nearly impossible to recreate the scenario that exists in court, where you have a witness in a box, everybody can see what's going on. You can see if they're communicating with anyone, you can see what they have in their hand. It's almost impossible to recreate that in the Zoom scenario. So it is a matter of weighing out the different pros and cons to make that decision and having that conversation with the client, because ultimately he's the decision maker, and he or she is the decision maker, and you have to discuss with him all those pros and cons about what's the quality of the evidence you're getting, what you're missing out on. And you'll also come into some obstacles with the judge and the Crown, because when you are asking to maybe have a complainant, show her video camera around her room, you might get some looks from a judge who says, oh, is that really necessary? I think they might want to believe that this nice lady's probably being honest, but it's our job to protect our client. And if all I can see is a door, I want to know who else is in the room. And I might want to ask you that every time we get back on the record. If we just took a break, let's do it again. Let's do the video, pan around again. And it's going to annoy everybody, but you got to do it. If you're going to be in a position where you're at the disadvantage, you have to make sure you're protecting your client still.
And
Perfect.
if I could, JP, just to add on that, let me be clear about Zoom and COVID. We're not going to be in COVID for the rest of our lives. What Zoom has done for us is allowed technology to come into the courtroom that it desperately needed. And for set dates, Crown pretrials, for judicial pretrials, absolutely. And in those rare circumstances where you have a client in custody and it means an earlier trial date, do it by Zoom, get it done. But if your client's out of custody, or it's a significant credibility case where you want the full force of staring down the whites of their eyes when you cross-examine them, you get into court and you fight in court.
Although when you just stared right in the camera there, I think you would have had me giving up everything there in cross-examination. So perhaps you can still make it work in Zoom. But I agree, certainly with credibility issues, you definitely want to have it in person. So thank you to all 5 of you for taking the time for such an exceptional presentation. I think it covered everything there from the bail hearing right till trial. And we talked a bit about sentencing there. I think it was an excellent overview, and I hope all my students there helps them, first of all, get through their exams next week and understand all of these concepts. I was wondering maybe we could end with all 5 of you having some very brief final words of advice. Maybe we can start in the same order from Paula, and then we could end with you, Roots. And I see that the passion that all of you have for working in criminal defense, and a lot of students sometimes they have this. They're afraid of, if they get into criminal law, people like, oh, you're the guy helping the bad people out there. How do you sleep at night? And in particular, dealing with some of the clients that you may have and reviewing some of the disclosure that you see, how do you manage to kind of compartmentalize all of that in the rest of your lives, right? And I think especially for paralegals, certainly they have a limited scope in criminal law, and I'd like to see more paralegals practicing in that area because there is a lot of summary matters that you can take on, and traditionally it ends up being a lot less paralegals there compared to small claims and landlord and tenant. So perhaps we could start with you, Paula, and thanks again to all of you for joining us here today.
Well, I do get asked that question a lot. I think all my colleagues do. And when they ask me how do I sleep at night, I say very well. Because aside, again, as I said, innocent until proven guilty, the thing is, when someone's charged with a criminal offense, it doesn't mean that they're guilty of that charge. As I said before, police officers, they don't all know the law. They are not the judge and jury. They just hear an allegation, they just do their job, they charge the person, and they let the courts figure it out. So not even a client knows whether they're guilty. Sometimes they think they're guilty of something when the law is they're not guilty of anything, or they're not guilty of what they've been charged with. So for me, some of the things I love about this career is that when someone's charged with a criminal offense, it's embarrassing, it's humiliating. They feel out of control with their life because their job could be at risk, their relationships are at stake. And for me, I like to start off with making the client feel well-informed and empowered with information, knowing about the process in detail. I always make myself available to the client because this is, it's a very stressful situation to be in. And so when you get the disclosure, as I said, the case always looks bad at the start, because the police they're going to write their summary and their synopsis of what they think the allegations are. And then when you get the evidence, it's a whole other different situation altogether. It's never what it appears at the start, almost never. So I sleep well at night knowing that when I get the disclosure and I see exactly what the real lay of the land is, and that the client is not charged, the evidence shows that it doesn't make out the charge for which the offense for which they've been charged. And I'm fighting for that client's rights because that client could be impacted for the rest of their life if they're found guilty. this office is not the kind of law office where we just tell people, you know what, just resolve it and then go about your life. Some people there, it's so stressful on them, they just want to resolve. No, we work it out right through from the start to the end with them. And we demonstrate to them, look, I appreciate this is a horrible thing to have to go through. We are here for you. We will get you through this process. We'll make sure you're well informed at all times about the process and the law and how it works, what evidence we need, what we need to build a defense for you. And we will work it out with you. We let them know what the consequences are of taking it in certain directions. But at the end of the day, we want our clients to feel empowered. We want them to feel confident that at the end of the day, regardless, because no prudent lawyer could ever guarantee what the end result is. Of course, we want an outright acquittal or withdrawal, but no prudent lawyer can read the mind of a judge and determine what the ultimate decision is going to be. But what we can say is that we are going to give you the best fight and the best results possible in those circumstances. And even if worst case scenario, a client's dead in the water, they're for sure guilty. There's no defense available to them. Our job, and I think this is the misinformation a lot of people have about defense counsels, is that, even if they're dead in the water, we just fight and say, you know what, no, not guilty, not guilty, and we take it to trial. That's not how we work. We, as officers of the court, we're required to demonstrate to the client what we need and what they have and what they don't have. And if they don't have a defense available to them at all, then what we do is try to work out the best resolution for them. So if it's no point of taking it to a trial because that could make the situation much worse for them, then we want to try to mitigate the circumstances to get the best resolution possible. So that's how we sleep well at night, knowing that if we're taking it to trial, we are getting the best results possible for them. If we are resolving the matter, if they're going to end up pleading guilty, we are getting the best resolution possible for them. And that's how we sleep well doing our advocacy and representing our clients and giving them our all.
Thank you so much, Paula. I think we can go to Serena next.
What? I have to follow that amazing speech, really? I do echo the same thing that Paula said. However, I would also like to add that at the end of the day, police officers also can't be allowed to infringe on people's rights. They have a code that they have to adhere to. It's called the Charter of Rights and Freedoms, and every single person is allotted those rights. It doesn't matter if it's someone who had a petty theft. It doesn't matter if it's someone who's accused of murder. At the end of the day, we can't trample on people's rights and then call them the bad guy. Everyone is held to a standard, and police officers are no different. So for how we sleep at night, it's making sure that the world is actually a better place, that everyone's rights are not being infringed upon, and that people are held to a standard.
Thank you, Serena. Dakshini?
I think it was a friend of mine that once said it was like when you're in elementary school and you get in trouble and you get sent to the principal's office, and the other kid who's accusing you of something is standing there making up lies, and the teacher's looking at you like you did something wrong, and the principal's looking at you like you did something wrong. And then your parent gets there and you think, there's one person that's going to believe me. There's one person that's in my corner that's going to defend me. And my friend compared that to what lawyers are like. And I think that example is always stuck in my head, that everyone in a criminal court system is against your client. Everyone assumes your client did it. They talk about your client like they did it. They treat your client like you did it, even much more worse if your client's incarcerated, and you are the one person that's in that person's corner. And so you have to take that role very seriously, and you have to make sure you play that role for the person, because you are this beacon of hope for this person that's thinking, this lawyer is going to help me. She's going to protect my rights. She's going to make sure I get a fair trial. And I love that example of what role we play in our clients' lives. So I have no trouble sleeping and I have no trouble doing this kind of work because I think it's just so important that everybody has at least one person in their corner.
Now, Roxana, certainly you've learned so much, I'm sure, from all the wonderful women here at Roots of Law. And perhaps maybe you can share now, certainly you've listened to hundreds of people over the last year and some of your classmates or some of the students who are still in the program, what you learn now when you take the theoretical knowledge and now you have a practical experience, and what's that like, and maybe share what it's like for those later on once they get through the program that they can have work doing what you're doing while waiting to get your license or pursuing potential future education opportunities.
Of course. Well, my two pieces of advice, the first one would be to know what you're good at and to also push yourself out of your comfort zone. How I've gotten to know Roots was through a CPD about summary convictions. And I was just trying to learn more about summary law because that's the course I was taking at that time. And I was really inspired and I found her information to be valuable. So I actually reached out to her and sent her an email. I invited her as a guest speaker and kind of just gushed the admiration I had for her. And at that time, I couldn't see myself working at a criminal firm. I thought that's going to be some pretty hard stuff to watch. So probably can't do it. That sounds kind of terrifying. Like, I don't know if I could handle it. And once I pushed myself out of that comfort zone, I kind of created a safeguard for myself by creating this mentorship relationship. And I knew what I was good at is helping people and paying great attention to details. So that's what gives me a sense of fulfillment and continues to have me pushed outside of my comfort zone. You're not always going to know everything, and that's okay. You're here to learn. So just knowing who you could learn from and pushing yourself to actually ask those questions is how I got to where I am today.
Thank you so much, Roxana. And finally, Roots, I guess it is your firm there. So I'll give you the final words there to share with my students. And certainly I'm very appreciative. I'm very thankful because I think it's going to make the rest of my class go a lot easier. I think actually I teach this with another group of students on Thursday. I'm like, oh, maybe you guys can just go to YouTube and hit play and I'll see you in a couple hours. I'm sort of half joking on it, but definitely a lot of valuable information. And I really appreciate you taking the time, and everyone here at Roots of Law for taking the time and sharing all that. It was really well put together, well organized, and laid out kind of exactly of the questions that people may have from the beginning right to the end. So anything you can share from your many years of experience for those looking to get into the field, why they should be doing and becoming criminal defense lawyers or involved in the criminal defense profession.
Yeah, I'm going to be repetitive to a certain extent. This is a calling. It's not a job, it's a calling. If you truly understand and value the importance of the individual facing the mammoth Goliath, David and Goliath storyline, if you understand how important it is to have a lawyer stand by your side, to understand that charter rights are integral to each and every single Canadian citizen in this country, and we're all equal before the law, to understand how important it is to be valued and to have information and to have an understanding of what it is that this process is going to entail. All of those features are why we do this work. The end result is that you can change the trajectory of somebody's life, and not only their life, but the lives of their family members, their children, and generations to come. And you may not see it that way, but in my almost 25 years, I've seen clients come through who are facing penitentiary sentences, for whom the work was done with the dignity and respect that they deserved, and they walked away unscathed. And they were able to go on to get a job and continue their education and raise a family and take with them a sense of having been given a second chance. Because everybody deserves a second chance in life. And if in doing the work that we do, we can give somebody an opportunity to be a better person, to go on with their life and to be a serving member of the community, then it's worth everything. It's worth all the horror of being yelled at by judges. It's worth the horror of being talked about by crowns behind your back that you're, I won't get into the language that they use about me, but the bottom line is this is a calling. If you want to do this type of work, do it because you love what it is that you're trying to accomplish. There is a hitch to this. I don't know where you people get lives. I haven't had a life. My work-life balance disappeared a long time ago. And I have to say that it's only been in the last few years that I've begun to recognize that the life-work balance is integral to keeping sane in this business. This is a hard business. It tears you to pieces sometimes. And the things that you see, the underbelly of society, can really wreck your view of the world. And it has to be at some point that you look after yourself, that you look after the people in your life, and that you have a good life. Go for hiking trips with your dog on the weekends, get engaged and have fun with your future husband to be, spend the time doing the things that you like, whether it's camping or hiking or painting by paint by numbers. Do something that you can take yourself out of in order to give the most of yourself into, because that's what this business demands. It demands the most of you, and you can't give the most of you unless you have that to give. So figure out the work-life balance, have fun, and fight the power.
Thank you all so much. I wish you all the best in fighting the power. I'm sure you have a trial or something to do for the next couple of days there. So good luck with all of that, and stay safe during these uncertain times. And it looks like we're reaching the light at the end of the tunnel, hopefully, where you see maybe a hybrid approach that we was talking about with set dates. Maybe the only difficulty there with set dates I find is people learning to hit the mute button, but that's another battle for another day. So take care, everyone, and thank you for everyone for listening, and all the best. Bye for now.
Thank you.
Thank you.
Take care.
Thank you for having me. Bye, everyone.
Bye.
Have a good night, guys. Thank you.
Bye.